Madam Registrar, would you please call the case?
This is the case IT 0690T, the prosecutor versus Ante Gotovina, Čermak and Mladen, Markač.
Thank you, Madam Registrar. The Chamber is sitting today to deliver its judgment in the case of the prosecutor versus Ante Gotovina, Čermak and Mladen Markač. For the purposes of this hearing, the Chamber will briefly summarize its findings. I stress that it's a summary only. The authoritative account of the Chamber's findings can be found in the written judgment, which will be made available at the end of this session. This case concerns crimes allegedly committed from at least July 1995 to about the 30th of September 1995 against the Krajina Serb population and property owned or inhabited by Serbs in various municipalities in the Krajina region. The crimes alleged by the prosecution include deportation and forcible transfer, plunder of public and or private property, wanton destruction, murder, inhumane acts, and cruel treatment. The crimes alleged further include persecution, including through unlawful attacks on civilians and civilian objects, unlawful detentions, and the imposition of restrictive and discriminatory measures. Ante Gotovina, Čermak, and Mladen Markač stood trial as alleged participants in a joint criminal enterprise. The objective of this alleged criminal enterprise was the permanent removal of the Serb population from the Krajina region. According to the prosecution, the enterprise amounted to or involved the commission of the crimes of persecution, deportation and forcible transfer, plunder and destruction. Alternatively, these crimes were a natural and foreseeable consequence of the execution of the enterprise. In addition, the crimes of murder, inhumane acts, and cruel treatment were also a natural and foreseeable consequence of the execution of the alleged joint criminal enterprise. According to the prosecution, the members of this joint criminal enterprise included, in addition to the three accused, Croatian President Franjo Tuđman, Minister of Defense Gojko Šušak, and the successive chiefs of the main staff of the Croatian army, Janko Bobetko and Zvonimir Červenko. These members of the joint criminal enterprise allegedly used or cooperated with others to facilitate or carry out the crimes. These others included government officials and members of the Croatian army, the military police, the special police, and the civilian police. According to the prosecution, the accused participated in and acted in furtherance of the joint criminal enterprise in various ways. According to the indictment, the accused were responsible for having planned, instigated, ordered, or aided and abetted these crimes. Finally, the prosecution alleged that the accused were criminally liable for having knowingly failed to prevent or punish criminal acts or omissions of their subordinates. This trial chamber heard and considered this case over a period of more than 3 years. all of the parties, as well as the chamber itself, called witnesses during different phases of the case. In total, 145 witnesses were called to give evidence, and the chamber admitted written evidence of another 38 witnesses. In addition, the parties introduced a vast amount of documentary evidence for the chamber's consideration. This included military documentation, reports from international organizations active in Croatia during the indictment period, and reports from various experts. The parties in the chamber dealt with numerous procedural matters during the trial. One such procedural matter was the prosecution's request on the 13th of June 2008 to order the Republic of Croatia to produce certain documents or information, in particular a number of artillery documents. The prosecution's search for documents was initiated by requests for assistance to Croatia and was followed up with extensive litigation in which the parties and Croatia were involved. The chamber also invited Croatia to a number of meetings in an attempt to clarify whether certain artillery documents existed and, if so, where they could be found. During this process, some documents were provided to the satisfaction of the prosecution, while others surfaced only gradually. Others still were never provided. On the 26th of July 2010, the chamber, although recognizing that a number of questions with regard to the missing artillery documents remained without definitive answers, denied the prosecution's request to order the Republic of Croatia to produce certain documents. The chamber stressed that Croatia was still under an obligation to cooperate with the tribunal. The chamber notes that the events in this case took place in the context of many years of tension between Serbs and Croats in the Krajina. In this regard, the parties agreed that a considerable number of crimes had been committed against Croats in the Krajina. The events in this case also took place in the context of an armed conflict in the territory of the former Yugoslavia that had been ongoing for years. However, this case was not about crimes happening before the indictment period, nor was it about the lawfulness of resorting to and conducting war as such. This case was about whether Serb civilians in the Krajina were the targets of crimes and whether the accused should be held criminally liable for these crimes. The chamber will now give a summary of its findings. On the basis of the evidence before it, and in accordance with an agreement between two of the defense parties and the prosecution, the chamber found that an international armed conflict existed throughout the indictment period and area. The chamber received and considered evidence on a large number of specific incidents of alleged murders. Much of this evidence came from family members of victims and from international observers. For instance, one witness testified that on the 7th of August 1995, he heard the sound of shooting and saw Croatian soldiers just outside his house in Mokropolje in Ervenik municipality. He overheard a conversation in which somebody said, and I quote, "I killed another one." End of quote. Whereupon the witness went downstairs and found his elderly mother and his mentally ill brother, who had both been shot. The chamber found that they were murdered by Croatian soldiers. Another witness testified that on the 6th of August 1995, she witnessed Croatian soldiers taking 5 men out of the basement of a house in or near Očestovo, where she was also being held. One of the men was her son. Shortly thereafter, gunshots could be heard, and later the 5 men were found dead by gunshot wounds. The chamber found that members of the Croatian army murdered the 5 men. The chamber found that members of the Croatian military forces and the special police committed a number of murders charged as war crimes and crimes against humanity. The chamber further received and considered evidence on a number of specific incidents of alleged cruel treatment and inhumane acts. One witness stated that on a morning, no later than the 12th of August 1995 in Palanka, Croatian soldiers searched his home, asked for money, and then tied him to a tree. They then put some textiles beneath his feet and set them alight. In pain from the fire, the witness kicked the textiles away. In this and other incidents, the chamber found that members of the Croatian military forces or the special police committed acts of cruel treatment and inhumane acts charged as war crimes and crimes against humanity. The chamber further received and considered evidence on a very large number of incidents of alleged plunder and destruction. As an example, the chamber refers to incidents reported in Markač and Knin municipalities. Witness Steenbergen testified to seeing extensive destruction, such as burnt houses in Markač on the 6th of August 1995, including houses which were at the time still on fire. Many witnesses, such as Widen and Boucher, also testified to seeing military trucks loaded with electronic equipment and furniture, leaving Knin on the 6th of August 1995 without being stopped at Croatian checkpoints. In these and the number of other incidents, the chamber found that members of Croatian military forces or the special police committed acts of destruction and plunder charged as war crimes and as underlying acts of persecution. With regard to the unlawful attacks on civilians and civilian objects as an act of persecution, the chamber found that on the 4th and the 5th of August 1995, artillery units fired artillery projectiles at the towns of Knin, Benkovac, Markač, and Obrovac. The chamber received evidence regarding the targets that the Croatian army had identified in these towns from the chief of artillery of the Split military district, Marko Rajčić, and in the form of a number of target lists and artillery reports. the Chamber notes that it may not have received in evidence all artillery documents which were compiled at the time. A number of international observers and Croatian Serb residents who were present in these towns at the time of the shelling testified about the location of impacts. The Chamber carefully compared the evidence on the locations of impacts in these towns with the locations of possible military targets. Based on this comparison and the relevant artillery orders and reports, the Chamber concluded that the Croatian forces deliberately targeted in these towns not only previously identified military targets, but also areas devoid of such military targets. As such, the Chamber found that the Croatian forces treated the towns themselves as targets for artillery fire. The Chamber thus found that the shelling of Benkovac, Markač, Knin and Obrovac on the 4th and the 5th of August 1995 constituted an indiscriminate attack on these towns and an unlawful attack on civilians and civilian objects. With regard to the alleged forcible transfer and deportation, the Chamber considered that on the 4th and the 5th of August 1995, large numbers of persons left the towns of Benkovac, Markač, Knin and Obrovac and went to Bosnia-Herzegovina and Serbia. The trial chamber considered that although there were Croatian Serb evacuation plans for certain municipalities, the extent to which they were implemented varied. Moreover, the population was already on the move by the time the Serb municipal authorities took action, and when Serb Croatian President Markač ordered an evacuation late in the afternoon of the 4th of August. The trial chamber concluded that the evacuation plans and orders of the Croatian Serb authorities had little or no influence on the departure of Croatian Serbs. With respect to Benkovac, Markač, Knin and Obrovac, the chamber concluded that the fear of violence and duress caused by the shelling created an environment in which those present there had no choice but to leave. For instance, one witness testified that the shells, which fell everywhere in Knin, appeared to have been aimed at scaring people and made everyone feel like they had to flee. Many persons sought refuge at the UN compound, a number of whom were eventually transferred to Serbia. The chamber further found that crimes, including murder, destruction, plunder, and inhumane acts committed by members of the Croatian military forces and special police caused duress and fear of violence in their victims and those who witnessed them. These crimes added to the creation of an environment in which these persons had no choice but to leave. The chamber found that the forcible displacement committed by members of the Croatian military forces and special police by the unlawful attacks on towns in the Croatian on the 4th and 5th of August 1995 and by the commission of other crimes later in August 1995 constituted deportation.